Okay, let's get into this deep dive. We're looking at the really complex and frankly tragic case of R versus Robert Borkowski.
Yeah, it's a heavy one. We've got all the sources you shared, the judgment itself, articles, notes, quite a stack.
Exactly. And our goal here is to try and make sense of it all. The events of that night, the people involved, that really winding legal path it took.
And crucially, how this one case ended up leaving, well, quite a significant mark on the law, especially here in New South Wales.
It really did. It's fascinating how one incident can ripple out like that. To understand it, we really have to start at the beginning, paint the picture.
We do. Go back to that Sunday evening, July 29th, 2007. We're talking around 6:2 a.m.
The location is the Great Western Highway, St. Mary's, out in western Sydney. Big road, usually just traffic, normal life.
But not this night. The sources, they describe the ordinary rhythm being just shattered, the roar of engines.
Yeah, that's the phrase they use. Robert Borkowski, Adam McDonald, Craig Johnson, they basically turned this public highway into, well, a racetrack.
A lethal one. The court called it a lethal exhibition of speed and recklessness. And it wasn't just, speeding a bit.
No, this was a full-on race, over about 5 kilometers, apparently. Weaving through traffic, flooring it from the lights.
Just incredibly dangerous driving, ignoring every chance they had to just, back off, stop.
And the speeds. Just terrifying for what was a 60-kilometer zone. Borkowski estimated at 120 clicks at impact.
And his speedometer, they found it frozen at 130 kilometer rate. McDonald was hitting 100 just before he braked. It's cold, yeah.
And then completely separate from all this madness, you have Alan Howell, 71, and his wife Judith, 70.
Just doing something completely ordinary, making a right turn in their Toyota Camry.
A simple everyday maneuver. But they turned right into the path of this oncoming danger.
The collision was described in the sources simply as an explosion. Borkowski's Commodore hitting the Howell's Camry. Just devastating force.
Alan Howell was actually thrown from the car. He died instantly.
And Judith Howell suffered terrible injuries. She also died there, at the scene. The impact threw their car 35 meters.
35 meters. It's hard to even picture that kind of force.
The aftermath sounds chaotic. Borkowski's car spinning, hitting McDonald's car, spinning again.
In Johnson, the third driver. He swerved, avoided it all, and just kept going. Didn't stop.
Chilling, isn't it? Borkowski himself had relatively minor injuries, was taken to hospital.
And the tests later showed, well, a blood alcohol reading of 0.031, but the expert calculated it back to probably 0.063 at the time of the crash.
So just over the legal limit. And there was also residue of cannabis and methamphetamine in his system.
McDonald's sample also showed cannabis residue.
It just paints a picture of, multiple factors contributing to this utter recklessness, the substances, the decision to race.
And that horrific night, the crash itself, that wasn't the end of the story. Legally speaking, it was just the beginning.
Right. This tragedy triggered a really significant legal journey. And that's what we're diving into.
Well, look at the key people. Trace the case through the courts. It wasn't straightforward. Unpack the big legal fights on appeal.
And see what the lasting impact was. Why this case matters in the bigger picture of the law. So think of this as your guide through that whole process.
Okay, let's start with the people involved. The dramatis personae, as the judgment might put it.
First, and most importantly, the victims. Alan and Judith Howell, 71 and 70.
Just a respected elderly couple. Their loss left this huge hole in their family. 7 kids, 15 grandkids, a great-grandchild on the way.
The victim impact statements read in court, they were just heartbreaking. Their daughter, Catherine Przybilla, she called her parents the foundation of our houses, our hearts, our lives.
And said their hearts were shattered forever. Just devastating words.
Another son, Philip Howell, he expressed the family's hope that the sentences would somehow help protect other innocent people. The court reports mentioned dozens of relatives there, openly weeping.
It really brings home the human cost, doesn't it? Beyond the legal arguments.
Absolutely. Then you have the defendant, Robert James Borkowski. He was 37 at the time. Born 1970.
The driver whose actions directly caused the deaths. The court called him an active and willing participant in that race.
And the sources detail a pretty extensive prior criminal record. Things like malicious damage, dishonesty offenses.
There's a child sexual assault charge back in 1998, drug possession. And a significant traffic history, too.
Yeah, multiple PCA offenses. That's drink driving, driving whilst disqualified, running red lights, illegal U-turns. His last major driving offense before this was 2001, though.
There was a psychological report mentioned, too. Said he had average intellect, but also a personality disorder. Issues with impulse control, substance abuse predisposition, low frustration tolerance.
But the report also noted he seemed remorseful, accepted responsibility, hoped for a better life. Risk of reoffending assessed as moderate.
He apparently said something like, "There's not a night that goes by that I don't relive the horror of what I did."
It's important to include that perspective, mentioned in the sources, alongside the objective facts of his history and actions.
Okay, then the co-offenders. Adam McDonald. He was 29 then.
Driving one of the other cars in the race. His car actually hit Borkowski's after Borkowski hit the Howells.
And his legal path was different, wasn't it?
Yes, significantly. McDonald pleaded guilty to 2 counts of manslaughter much earlier in the local court.
Okay, so before it even got to the district court stage for trial.
Exactly. He was committed just for sentence, and later in the district court, he got 8 years total with a 5-year non-parole period.
And this is critical. The Crown decided not to appeal McDonald's sentence.
That decision hangs over the rest of the case, as we'll see.
And the third driver, Craig Johnson.
He managed to swerve, didn't hit anyone, didn't stop, but he actually died sometime after the incident, before the appeal was finalized.
So he faced no further legal consequences in relation to this specific matter.
Correct. Now, the judiciary. The judge who sentenced Borkowski was His Honor Judge William Knight in the Penrith District Court.
What did he say at sentencing?
He described the driving as totally irresponsible, showing no regard for the rights of others, said the community was fed up, and the risk tragically materialized.
But the appeal court wasn't entirely happy with his description.
No, the Court of Criminal Appeal later criticized him for calling it mere stupidity. They said that description falls well below a proper characterization of such serious criminal behavior. Judge Knight passed away in 2017.
Then the appeal went to the NSW Court of Criminal Appeal, a bench of 3 judges.
Yes. First, the Honorable Justice Peter McClellan, who was the chief judge at common law then, very experienced. He agreed with the main judgment.
Then the Honorable Justice Carolyn Simpson.
A real trailblazer. Second woman on the NSW Supreme Court bench, known for her sharp mind, wisdom, elegant judgments.
And she wrote something particularly interesting in this case.
She did. She agreed with the outcome, but wrote separately to expressly reserve her position on a key legal precedent about manslaughter, R.V. Pullman. She called its conclusions extremely broad.
So, questioning established law.
Essentially asking whether a really dangerous breach of traffic law couldn't in fact be the unlawfulness needed for manslaughter. It hinted at a potential shift, showed how legal minds constantly reevaluate things.
Fascinating. And the judge who wrote the main, detailed judgment.
That was the Honorable Justice Roderick Howie. He had this incredibly diverse background: former police officer, public defender, Crown prosecutor, textbook co-author.
Wow, he'd seen the system from all sides.
Absolutely. Known for being absolutely straight down the middle, with a really deep grasp of criminal law. That varied experience shines through in his meticulous analysis.
It really shows how that collective wisdom shapes the law, doesn't it? Different perspectives coming together.
Definitely. And Justice Simpson's point shows it's not always unanimous agreement on the underlying principles, even when they agree on the result.
We should also name the lawyers involved, specifically at the appeal stage. The sources list them.
Right. For the Crown, appealing the sentence, counsel was M. Grogan, a Crown prosecutor. The instructing solicitor was S. Kavanaugh from the Crown Solicitor's Office.
In representing Robert Borkowski, the respondent on appeal.
Counsel was H. Donji, a barrister from Forbes Chambers. The solicitor was S. O'Connor.
And Hement Banji, he later became a judge himself.
Yes, appointed to the Supreme Court of NSW as Justice Donji in 2021. It just highlights the caliber of legal minds involved in arguing these points at the highest level.
The source notes Philip Young was Borkowski's counsel back at the original sentencing before Judge Knight.
Good point. Different counsel at different stages.
Okay, so we have the people. Now let's trace the case's journey through the courts. It was quite a winding path.
It started, of course, with the crash on July 29, 2007.
Then, just 2 days later, July 31st, Borkowski presents himself to the police, admits he was driving. Arrested. Bail refused.
And he stayed in custody from that date right through.
The initial charges laid, according to early reports, were things like dangerous driving causing death, street racing.
But these often evolve as the investigation progresses. They eventually settled on the more serious manslaughter charges.
Before it got to the district court, there were committal proceedings in the local court. And they were contested.
Yes, witnesses were called. And a key point of dispute was whether Borkowski ran a red light during the race. The Crown alleged he did. He denied it.
So that factual dispute added time.
Definitely. Contested committals take longer, and interestingly, the Crown eventually dropped that specific red light allegation later on.
Okay. Then on June 18th, 2008, he was committed for trial. The case moves up to the district court.
But even then, more delays. The arraignment where he'd formally enter a plea was listed twice, July 31st and August 28th, 2008.
And both times it was adjourned.
Yeah, at the request of Borkowski's legal team, pushing things back further.
The plea finally happened on September 11th, 2008, in Penrith District Court before Judge Knight.
A crucial turning point. He pleaded guilty to 2 counts of manslaughter.
And the basis for that plea was stated as unlawful and dangerous act, manslaughter.
Right. But the statement of facts didn't precisely spell out what the underlying unlawful act was. That lack of detail, that specific characterization, became an issue later.
And meanwhile, Adam McDonald had already pleaded guilty way back in the local court.
Correct. His path was separate by this stage, committed solely for sentence.
Then sentencing day for both, November 5, 2008, Judge Knight.
Borkowski gets 9 years total, 6 years non-parole, backdated to his arrest in July 2007, plus a 6-year driving disqualification.
And McDonald.
8 years total, 5 years non-parole. His sentence started from that day, November 5th, 2008.
Right after sentencing, the appeals started. The Crown appealed Borkowski's sentence, said it was manifestly inadequate.
And McDonald appealed his own sentence, arguing it was too harsh and also raised disparity with Borkowski.
But again, the crucial point, the Crown did not appeal McDonald's sentence.
Even though it was arguably lenient too, and McDonald himself was appealing it partly based on disparity, a very significant strategic choice by the Crown.
The Court of Criminal Appeal hearing for the Crown's appeal against Borkowski was March 17, 2009. We had Grogan and Kavanaugh for the Crown, Donji and O'Connor for Borkowski.
McDonald's own appeal was adjourned that day, apparently not opposed by the Crown.
And the judgment from the CCA came down on April 15, 2009. Justices McClellan, Simpson, and Howie.
And the outcome. Despite finding errors, they dismissed the Crown appeal against Borkowski's sentence.
So, quite a journey. Crash, arrest, charge evolution, contested committal, delays, late plea on a specific basis, separate paths for co-offenders, appeals, a key non-appeal.
It really maps out the procedural complexity, and the appeal itself drilled down into some fundamental legal issues.
Let's get into those key legal arguments. Ground one for the Crown was about that 25% discount Borkowski got for his guilty plea.
Yeah, the maximum discount. But he only pleaded at arraignment in the district court 13 months after arrest, after contested committal. That seemed late for the full discount.
Judge Knight justified it based on what a supposed local practice in Penrith, saying arraignment was the point for the max discount there.
That's what he seemed to suggest. And he downplayed the value of earlier pleas, like in the local court, seeing them more as just showing remorse.
Even the Crown prosecutor at sentencing conceded maybe 22.5% was okay.
Right. But the judge gave the full 25%. The CCA found this was clearly wrong, a miscarriage of discretion.
Justice Howie firmly rejected that idea of local practice, said it was inconsistent with the key case, R.V. Thompson and Holton.
He was emphatic, offensive to the principle that equal justice applies. You can't have different sentencing rules depending on which courthouse you're in.
And the fact McDonald got the same 25% for a much earlier plea just highlighted the inconsistency.
The CCA also corrected the idea that local court pleas are only about remorse, or that there's a separate discount for remorse on top of the utilitarian value.
This led to Justice Howie laying out those Borkowski principles, didn't it?
Exactly. 12 points clarifying how plea discounts should work, emphasizing timing is key, rejecting local variations, aimed at standardizing things statewide.
Okay, so clear error found, but they didn't actually reduce the discount.
No, because the Crown prosecutor at the original sentencing had conceded that 22.5% was acceptable. The appeal court felt bound by that concession.
Wow, so the prosecutor's actions at the first hearing tie the appeal court's hands.
It often does. What happens at first instance really matters.
Okay, second ground of appeal, the delay. Judge Knight treated the 15-month delay from arrest to sentence as a mitigating factor, giving a discount.
He relied on cases like R.V. Todd, the sword of Damocles idea, stress of waiting, good behavior on remand.
But the Crown argued Todd didn't apply here.
Right.
Because Borkowski himself caused much of the delay.
Exactly. By contesting the committal, seeking adjournments, and they argue there was no specific evidence the delay had a uniquely negative impact on him here.
And the CCA agreed with the Crown on this one, too.
Yes. Justice Howie said Todd was a very singular case, long delay, stale offense, not a universal rule. Leniency for delay depends heavily on why there was delay.
Little leniency if the offender caused it themselves.
Right. And the sort of Damocles idea didn't fit because Borkowski must have known a long sentence was coming anyway. Good behavior on remand is separate. Time served is covered by backdating.
So giving a specific discounting factor for delay here was another error.
Correct.
Third ground, Borkowski's criminal record. Crown argued it should have been treated as an aggravating factor, showing persistent lawbreaking, citing Veen, No. 2.
Judge Knight had acknowledged the record, but felt it didn't reach the Veen threshold for aggravation. He saw its effect as just canceling out any leniency he might otherwise get as a first offender.
And the CCA. Did they find error here?
No, not on this point. And again, it came back to the original sentencing hearing. The prosecutor hadn't argued the record was aggravating then.
They'd argued it militated against any degree of leniency. A subtle difference, but important.
It's very important. The CCA generally won't let the Crown strengthen its case on appeal like that, especially if their earlier stance contributed to the judge's approach. Whether a record aggravates or just negates leniency is for the sentencing judge to decide based on the arguments.
So 2 clear errors found plea discount, delay factor, but no error found on the criminal record point, largely due to the Crown's original position.
That's the summary of the specific grounds. But there was this other massive issue lurking the legal basis of the manslaughter plea itself.
The unlawful and dangerous act basis,
Yeah.
and the problem with R.V. Pullman.
Exactly. Pullman basically said the unlawful act has to be a crime in itself, not just breaking a regulation like a traffic rule.
And Borkowski's only clear unlawful act was the street racing, a traffic offense.
So under Pullman, that couldn't actually be the basis for this type of manslaughter. The CCA concluded the whole plea and sentence were technically misconceived, according to that precedent.
That sounds like a huge problem. Did they consider sending it back?
They did. But Borkowski's counsel argued that would be unfair, kind of like triple jeopardy, facing the conviction issue again, potentially getting a higher sentence. Justice Howie saw merit in that fairness argument.
And this is where Justice Simpson's separate judgment really stands out.
Absolutely. She agreed with the outcome, but specifically said she had reservations about Pullman, called its conclusions extremely broad, questioned why a really dangerous traffic breach couldn't qualify as the unlawful act.
So she was basically flagging Pullman itself as potentially problematic.
Pretty much, signaling that maybe that doctrine needed another look. It shows the common law evolving, being questioned from within.
Justice Howie also mentioned the hierarchy of offenses, didn't he? Manslaughter being at the top for vehicle deaths.
Yes, he suggested Judge Knight hadn't properly placed the offending at that pinnacle, possibly because of the confusion caused by the Pullman issue and the way the plea was framed. He blamed the prosecutor for that erroneous approach.
It keeps coming back to the prosecution's choices, doesn't it? Framing the play, the concessions, not arguing aggravation, and especially not appealing McDonald.
They fundamentally shaped the legal landscape the CCA had to navigate.
Which leads us, finally, to the decision. Despite finding errors, despite calling the sentence manifestly inadequate, the Court of Criminal Appeal dismissed the Crown's appeal. Explain that again.
Okay, so they found the 2 errors. Plea discount, delay mitigation. They stated very clearly the sentence was way too low. Justice Howie said Judge Knight must have very substantially underestimated the criminality involved.
He used strong language about the seriousness.
Extremely strong. Utmost seriousness, flagrant breach, loss of life almost inevitable, joint enterprise, increasing danger, ignored chances to stop. Very little in Borkowski's favor subjectively.
And he even said what he thought the minimum should be, 12 years total, 9 non-parole.
Yes, while acknowledging constraints on Crown appeals. So the sentence was clearly seen as inadequate, but the appeal was still dismissed.
Because of Adam McDonald.
Because of the unappealed sentence of Adam McDonald, that was the overriding factor in the court's discretion.
If they increased Borkowski's sentence to 129 years, while McDonald stated 85 years,
it would create a huge, unjustifiable disparity. A 9-year minimum versus a 5-year minimum for offenders they saw as potentially equally culpable, with nothing justifying that big a gap.
giving Borkowski a justifiable sense of grievance.
Exactly. Now, usually you don't reduce a correct sentence just because a co-offender got off lightly, Diamond Chen. But here, the Crown was asking the court to increase a sentence.
And by not appealing McDonald's sentence, the Crown had sort of implicitly accepted the existing relativities, or at least hadn't tried to fix McDonald's inadequacy.
Right. The court wouldn't step in to create a fresh injustice or disparity that stemmed partly from the Crown's own inaction.
So Justice Howie said they must exercise their discretion to dismiss the appeal because of that failure regarding the co-offender. Parity won out.
It was decisive, but even in dismissing, they sent clear messages. Justice Howie said the appeal's wider purpose, clarifying principles, ensuring consistency, was achieved.
By clearly stating the sentences were wrong and why, and that general deterrence would be served by their pronouncement on the proper penalty for future cases.
And that final pointed remark, attributing any public unhappiness with the outcome squarely to the conduct of the Crown, not the court's failure to recognize the seriousness.
That's a direct shot.
It is, placing responsibility very clearly.
So the sentence didn't change, but the judgment itself had a lasting impact.
Oh, absolutely, especially in NSW law.
Most directly, those Borkowski principles on guilty plea discounts.
Yeah, they provided real clarity, emphasizing timing, rejecting local variations. They're cited all the time in the sentencing bench book by lawyers, academics, foundational stuff, even if some nuances evolve.
It also gave strong guidance on sentencing for motor manslaughter, right? Even without changing this sentence.
Yes, the court's strong words on the sheer gravity set a benchmark, and the need to place manslaughter at the pinnacle of driving offenses, distinct from lesser statutory offenses. That hierarchy matters.
And it kept the debate around R.V. Pullman alive.
Definitely. By highlighting the difficulty of applying it to dangerous driving and having Justice Simpson expressly reserve her position, it showed this area of unlawful act manslaughter wasn't settled, still ripe for review or reform.
And the big lesson for prosecutors.
A huge one. The dismissal showed how parity, especially when influenced by Crown conduct, like not appealing a co-offender, can constrain appeals. That final remark from Justice Howie about public grievance being the Crown's responsibility, a stark reminder.
About careful strategy, consistent arguments, accurate submissions.
Exactly. And beyond the pure law, the case had that human element. The victim impact statements, even Borkowski's remorse statement, they add dimension. High-profile cases do raise public awareness of the human cost.
So when we pull back, what's the main takeaway from this deep dive into Borkowski?
It's just a fascinating window into the justice system's complexities. You see the tension between applying principles strictly and achieving broader fairness.
Finding the sentence inadequate, but dismissing the appeal because of parity. It shows that commitment to fairness, even if the result feels off in the one case.
It also shows the limits of accountability sometimes. Borkowski was convicted, served time, but the ultimate sentence wasn't what the appeal court thought it should be, partly due to procedural decisions and conduct. Law operates within rules, and human choices matter.
For you listening to this, what stands out? Is it the awful reminder of reckless driving's cost, the mechanics of plea discounts, or that complex dance between judges, lawyers, and legal principles?
And maybe the fact that law isn't static. The Borkowski principles became lasting guidance. Justice Simpson hinted at future change on Pullman. It's always evolving.
It's a somber case, obviously, reminding us of the cost of recklessness, but it offers so much insight into sentencing, prosecution, appeals, and how the law refines itself.
Absolutely. Thank you for bringing us the sources for this deep dive. It's been quite the journey unpacking this case with you.